for the fourth case on this morning's docket. That is case number 114863 in the matter of Lyle Odo.
May it please the court, the Office of the Disciplinary Administrator appears by Kimberly Knoll, Deputy Disciplinary Administrator. Mr. Chief Justice, I'd ask for 2 minutes for rebuttal.
2 minutes is granted.
As this court is aware, this is an original proceeding in attorney discipline. The respondent, Mr. Odo, is licensed in both Kansas and Missouri. He was suspended by the Missouri Supreme Court on September 30th of 2014. He has, in the interim, filed a reinstatement petition that is currently pending. The Kansas hearing panel adopted the Missouri hearing panel's findings of fact. The panel found that the respondent violated KRPC 1.7 by entering into loans that created a risk that the representation would be limited and the clients hadn't given written informed consent. The panel found that he violated KRPC 1.8 by charging extraordinary interest rates, failing to inform the clients in writing of the desirability of seeking independent legal counsel, not obtaining written informed consent, and advancing funds that were not for litigation. The reasons for the advancement of the funds that weren't for litigation, the panel found was a mitigating factor because it was due to the client having severe pain. The panel found that the respondent violated KRPC 1.9 by representing another client in an action against a former client. The panel found he violated KRPC 1.15 after he admitted that he commingled funds and basically used his trust account as his operating account. And finally, they found a violation of 8.4D for repeatedly engaging in conduct that amounted to a conflict of interest. They determined he caused actual injury, he had prior discipline that was remote from Missouri, he engaged in multiple offenses, the clients were vulnerable, he had been practicing for more than 35 years, and at the time of the hearing, he hadn't paid restitution. Since then, I believe counsel has filed the notice that he was not going to take exceptions to the final hearing report, and attached to that was the information regarding the claims from the Missouri Client Protection folks and the release of any claim by the two clients. So from my perspective, the restitution issue is over, that has been resolved. The other thing that the panel suggested was that he provide an apology to the two clients, and I was presented this morning with the letter that's been done. He was planning on producing that with his petition for reinstatement. So he has all of the documentation for his petition should this court go along with a recommendation for the year suspension. And I would ask that the court adopt that. The panel actually went for an indefinite suspension, but then permitted, providing he has a showing that he had complied with other things, that he would be able to apply for reinstatement within a year. And I think as the posture is right now, I think he is in that posture to apply after a year, and a straight up year suspension without a reinstatement hearing would be appropriate.
That's your position today?
That is my position today.
And the 1 year would be effective upon filing of the opinion?
Yes.
We're not talking about making it retroactive to the Missouri.
Well, we had that discussion at the panel, and I honestly, I've never had that question brought up. That normally retroactive suspensions in Kansas are for individuals who had been temporarily suspended. And so it's kind of like time served to put on my prosecutor hat. And I'm not sure how that works because he has been actively practicing in Kansas, and it would seem to me that if this court determines a year suspension, it's a year suspension. Obviously, this court can determine a lesser amount. I spoke with the attorney in Missouri that has his reinstatement petition. He filed it, I believe, in early October, and they are just running behind. There's no indication that there's a problem with it. It's just a matter of she's taking, folks in order, and they just haven't gotten to him yet.
I'd like to address the issue, a one-year suspension without any sort of hearing. Did I understand you correctly?
That is correct. And I didn't ask for a hearing originally because I believe that Missouri, through his process in Missouri, he was going to have to do the same things that Kansas required. And so for him to get reinstated in Missouri, which I had anticipated would happen before now, that all of that would be clarified. And based upon what he filed with his, I'm not going to take exceptions, relating to the restitution or the claim with the Missouri Client Protection Fund, that's been resolved, and I physically saw the letter of apology, so that would be part of his reinstatement request. I believe that you have to file something saying, I want to be reinstated, even with the suspension. So, and that at that point, we would certify or verify that everything had been accomplished. And I'm not even honestly sure that this court needs to put those conditions in its opinion as far as restitution in the letter. But that's entirely.
I'd like to also go to the issue of restitution. The panel ordered restitution, or I should say they recommended that he make restitution. And their order is dated December 4th, 2015. And then in reaction to that, as I understand it, Mr. Odo is now producing to you a settlement agreement that was dated February 22nd of 2012. So the panel apparently was not aware of that settlement agreement, is that correct?
That is correct. And I believe Mr. Hamill is intending on explaining that that was not part of his presentation before the panel. So we were not aware of that.
And do you know why, or is that a question
I
for
do.
Mr. Odo?
That's a question for them. I do not know why.
And just so I'm clear, you're asking us to suspend him for 1 year effective the date of our opinion.
Yes, Your Honor.
And then at what point in time, in your view, would he be eligible to request reinstatement? You said it's not just the expiration of a year and then he's reinstated. You suggested, I believe, that he had to file something formally with your office.
That could be an option. Traditionally your suspension for a definite term is just that. If there's no conditions and there's no 219 hearing on 365 days or 364 days before that next morning, he would be reactivated. And I honestly don't know what the mechanism here that you use to do that. We also have had situations that there is a requirement that they file the reinstatement questionnaire, and that would be something that we would have to look at and investigate. And if they're not certified, if we don't certify that they can come back, then we would file a request to have an actual hearing. Or you could have it with a 219 hearing.
What is your recommendation to us on how we proceed with discipline?
My recommendation is a straight year with no requirements, because he has fulfilled, as I stand here today, he has fulfilled everything that was discussed in the hearing panel report.
And just so I'm clear, are you saying 365 days after the release of our opinion, he is automatically reinstated, or that he has to give you something?
I do not require anything from him.
All right, thank you.
Okay.
Any further questions? Thank you, counsel.
Good morning. For the record, we really don't object to what counsel has stated. I think she's adequately summarized the situation. I do want to speak a little bit about her recommendation on a 1 year suspension. Essentially, this is a case where two complainants, Chad Morrison and Lori Ferris, at the same time in June of 2011, filed complaints against Mr. Odo, one in Missouri and one in Kansas. And for whatever reason, Missouri took it up first, and there was a hearing, and the results of that and the findings of that are stated very adequately in the final hearing report. Essentially, Missouri imposed a indefinite suspension, but said that he could apply for reinstatement in 1 year. That was effective in December of 2013, so as of December 2014, he could apply for reinstatement. He has done so in Missouri. And that application was not filed until sometime in late 2015, and the paperwork was finally submitted, and it was finally submitted to the state of Missouri, I believe in April of this year, March or April. We've contacted, he has an attorney who's assisting him in the state of Missouri with his application for reinstatement. He spoke with her a few days ago, and she indicated that the application is in the stack. It's being considered by the state of Missouri, and that they say they're backed up like everybody else is, and they hope to get to it either this summer or fall, maybe June to October. That's the anticipated time frame for them to rule. So the violations that were charged in Missouri, the ethical violations, are virtually the same as those charged in Kansas, and they're set forth in the final report, and I think it's on page 13, where they have different numbers, the numbers are essentially the same, and the violations are the same. So Mr. Odo has been called to answer in 2 states. He's admitted in both states. He has a license in both states on 2 occasions. And at our hearing, we did not challenge the findings in the Missouri court or by the Missouri panel. And so the one thing the reason I filed a response stating we don't object to the final hearing report except for these recommendations, which I think when you look at the documents that I attached to the answer, may be impossible for him to even comply with. I will say to the court that the Missouri made its final ruling, I think, on November 17th of 2015, or 4 years, but it was about 2 weeks after we had our hearing in Kansas before the panel. So we were not aware of what Missouri was going to do. But what they did do, they reported in a series of 3 letters, which I've attached. And
Excuse me, when you talk about what Missouri was going to do, you don't mean their
I don't mean the state of Missouri.
May I finish? You don't mean their disciplinary panel, you mean their client protection. Is
Absolutely.
that right? All right.
Absolutely. I'm sorry. And the letter that he got from I confused it because they do it through the state bar, and so I refer to the state of Missouri, but it's their client protection fund. That letter came to him on November 25th of 2015. We'd already had the hearing in this matter, so we didn't know how they were going to rule, and we didn't even raise restitution as an issue in our defense. We didn't really present a defense. We said we did it, and there's been a hearing, and we don't object. But my concern is that page 39 of the final hearing report does say that he can be reinstated upon that he be required to establish that he's made full restitution. That's at the bottom of page 21 on paragraph 39. That he has made full restitution to these 2 individuals. Well, the exhibit B that I've attached is what he presented to the state of Missouri, their client security fund, which included this release which legally prohibits the two complainants from making a claim against him. And so I don't know how he can ever establish that he's made restitution. It's kind of a catch-22. So that part of the recommendations of the panel, as far as his conditions of him being reinstated, I think would be impossible for him to comply with. He has already complied with the second condition, that he fully cooperate with the Missouri Client Protection Fund and pay any amounts that he's ordered to pay. Well, they found that his claim wasn't valid, so there's nothing for him to do there. He has no objection to being required to comply with any restitution that might be required by the Kansas Client Security Fund, but he'll make the same argument to them that he made to Missouri, and I would think that we would get the same result. This is not a criminal case, and there's not double jeopardy here, but it has a feeling a little bit of he's gone through it in Missouri, and he has to go through it again in Kansas, and he's licensed in both states, and he needs to. But I just think that the recommendations make it impossible for him to ever satisfy those recommendations and be reinstated.
When was the last time he actually practiced law in Missouri? Do you know?
I don't think he has since the suspension. Correct.
Okay. And has he been practicing in Kansas?
He
this
has
whole
not
time?
been, with one minor exception. He had submitted a Social Security claim for a client in Kansas, and he has done a limited amount of work to keep that going forward. Is that correct?
It's concluded, was concluded.
It was concluded.
So with putting that exception aside, when was the last time he actually was practicing law in Kansas?
October 1st, 2015. 14.
2014, October 1st of 2014.
Any further presentation, counsel?
No, Your Honor.
Chief, I-
Well, obviously, we don't object to the recommendation that he be suspended for 1 year. We would like to have a provision that says if he satisfies, he is reinstated in Missouri, that he'd be allowed at that point to make application for reinstatement to the state of Kansas.
Very well. Justice Stegall had a question.
Yes, one question, counsel. I hate to say this, but I'm at least still a little confused on the restitution issue. What you've said that it's impossible for him to comply. Why is it impossible? What makes it impossible?
Did you see Exhibit B that I filed?
Yes, but go ahead and articulate for
Well,
me again.
I think that my argument would be if you look at paragraphs 3, 4, and 5, which 3 is outlines all the claims that were filed in a litigation that was then pending in the state of Missouri involving Mr. Odo and the two claimants. And paragraph 4 describes the Kansas litigation that was filed at the same time between these people. And then you look at paragraph 11, which is the release. I just think that, and knowing that this document was signed by both of the claimants in this case, represented by counsel, Mr. Morrison actually.
Well, let me go at it this way.
Okay.
Have either of these claimants received any compensation for the harm they suffered?
I don't know that they have.
And that's my problem here. Yeah, I understand you're making an argument that your client may no longer have sort of legal liability, but that's different than restitution, isn't it?
Well, I get your point, and I think there's something to that, but what's the mechanism for him satisfy that.
Well, the mechanism is that we're here on a disciplinary matter, and there's authority to require restitution be made.
In what amount?
Well, that's what I'm just asking you to help me understand why you made the argument that it's impossible, and
There,
it's really not impossible, right? If there were an amount to be determined, and if assuming your client had the funds available, he could make restitution.
right.
Okay.
Theoretically. My problem with that is that, I mean, my client committed ethical violations, and he admits it, and he would be willing to compensate. On the other hand, there was a whole lot of litigation between his clients and him, and there was mediation ordered in Atchison County. A district court judge up there conducted the mediation.
I would understand that if your argument was that he has already made restitution, but that's not your argument.
Well, there was a dispute between he and
Okay.
the people that filed a claim against him.
My understanding, sorry, did I cut you off?
No, thank you.
My understanding is your argument is they have released him from all liability
Well, they
for,
have,
for any claims, therefore there is no claim upon which to make restitution.
Right.
Is that it?
right. And that's what I understand the moral issue that you're raising. But
Any more questions? Did you desire to have your client address the court or not?
Well, he would be happy to answer any questions. I can report to the court, there was some comments that he didn't show remorse in the Missouri proceeding. That was one of their findings. I can tell the court that he's not only is he remorseful, he understands the importance of these ethical rules, and he understands how they can how they're dangerous and how they can cause problems to his clients and to the legal profession. So he is remorseful for that. I can report that to the court. If you want to hear from him, he's here.
That is your call.
You know what I'm saying?
Yeah.
Okay.
May it please the court, my name is Lyle Odo. I was born and I grew up in the state of Missouri. I graduated from law school at UMKC in 1974. I passed the bar in Missouri in 1975, and after working for a circuit judge for a couple of years, I've been in private practice ever since. The history of my practice is that I have represented many clients in many different types of cases. I have had an informal admonition against me in 2006 by the state of Missouri as a result of a complaint filed by a client I represented in a domestic relations case. I have had no other admonitions and have not had any penalties imposed on me except for the suspension that was imposed by the Missouri Supreme Court, suspending my license to practice law effective September 30th of 2014. As my counsel has stated, the order was that I not be allowed to request reinstatement for a period of 12 months. Since then, in November of 2015, I have applied for reinstatement. On my part, through my attorney in Missouri, I have submitted all of the documents and answered the Missouri Office of Disciplinary Counsel's questionnaire. That happened after Christmas last year. As my counsel has stated, I am told by my attorney in Missouri that I am third in line for the reviewing counsel to review my questions and to review my case, and that I could expect some response from the Office of Disciplinary Counsel anytime in June upcoming through the fall. And that is because of the workload that the Office of Disciplinary Counsel has. I stand before you, and as my counsel has stated, I admit all of the ethical violations that I have committed. I apologize to Ms. Lori Ferris and Chad Morrison for the harm that I have caused. I apologize to this court for the facts that I have violated my oath as an attorney and that my conduct was prejudicial to the administration of justice. I placed my corporation and indirectly me above the duties that I owed my clients, and that because of that, I was justifiably suspended by the Missouri Supreme Court, and I invite this court to impose whatever the court believes is necessary for the conduct that I have caused and the ethical violations that I have committed in this state. Since my violation and suspension that was effective September 30th, 2014, I have placed my trust account in the hands of an attorney trustee who has administered my trust account continuously since my suspension. In my 40 years of practice, I have been an officer of the Platte County, Missouri Bar, and served in all of their offices of that bar association. I stand before you justifiably ashamed of what I've done. And I would like to be allowed to be reinstated when the court would deem just to practice in Kansas. With respect to my practice in Kansas since my suspension, I have not practiced law with the exception of the Social Security Disability Appeal that occurred in the spring of last year before an administrative law judge for the Social Security Administration. Other than that, I have not practiced law in Kansas, and I have not practiced law in Missouri since my suspension. Thank you.
What have you been doing for income since September 30, 2014, if you've not practiced law in Missouri and only that one occasion in Kansas?
I have been fortunate through my practice prior to suspension to have obtained a substantial jury verdict in a jury trial in February of 2014. And because of the attorney fees that I earned in that jury trial, and because of the attorney fees that I'm paid for a class action lawsuit that I filed on behalf of a client in the ASR HIP settlement, those monies have sustained me since my suspension.
Very well, thank you. Any more questions of either counsel?
Mr. Chief Justice, I have some questions for the disciplinary
Certainly.
administrator. If we're,
I just want to make sure that when I said both counsel, I
I'm
meant
sorry,
Mr.
thank
Odo and his lawyer. All right, thank you both. Thank you, sir.
Thank you.
Now, you had reserved 2 minutes for rebuttal, but regardless, I think Justice Stiegel has a question for you.
we want to jump right into my
Sure.
question. It has to do with what I was asking earlier about restitution.
Okay.
And that's my concern here. The hearing panel found that the the complainants were actually harmed based on as a result of the rule violations, right?
That is in the panel report.
And then in paragraph 29 of the hearing report, they made a factual finding of the existence of an aggravating factor, that being respondent has not made restitution, right?
That's what they say, yes.
And so I guess my question to you, and then in the recommendations, they recommend that prior to reinstatement, that the respondent be required to establish that he has made complete restitution, right?
That is what they say, yes.
So I don't understand how this production of this settlement agreement can establish that those factors have been met. Help
Well,
me
okay.
understand that.
If I may, this is from the transcript, and the question was asked, what, if any, kind of restitution have you made to the two victims in this case? And his response is, I've had no contact with either of the victims, and I've made no restitution to them. However, Mr. Morrison has made a claim against the Missouri Bar. I can't remember the name of the fund. And I say client protection perhaps, and he says, thank you. The Client Protection Fund. He's made claims that I owe him restitution. That committee met in September, and they're going to be making their findings and recommendations this month to the Missouri Supreme Court. And of course, whatever their decisions are, I will certainly abide by them. And so at the time, at least from my mindset, we were waiting to see what, if anything, came of the Missouri claim for their client protection. And in the materials that he filed with his non-exception, there is a letter dated November 25th of 2015 from Missouri that says that it didn't qualify for compensation.
Right. There's no restitution that he could owe to the Missouri Client Protection Fund because they didn't pay anything.
Right.
But why does that absolve the respondent of the responsibility to make full restitution to the injured parties?
Well, I guess it wasn't on our radar. There was no presentation of anything.
The hearing panel found that that there was actual harm and that no restitution was made, and then in their recommendations they recommend not only that he make restitution to the Missouri Client Protection Fund should funds be expended out of that, but they also say that he should be required to establish that he has made restitution to the complainants, CM and LF.
I agree that's what it says, but I don't honestly know, as I stand here, I don't even know what the restitution would be.
So, right, and that gets to the problem pointed out earlier, is we may have a problem knowing the amount, but I want to figure out the first question, which is, I'm just trying to understand why your recommendation today is that somehow restitution has been fully either established or made, when it is not at all clear to me that it has been made.
Well, I guess I have two thoughts on that. One, the Missouri Client Protection folks looked at it and determined it wasn't compensable for whatever reason. And two, there's not a claim filed in Kansas, which they had the opportunity and could have done. We don't have a CPF claim from these two individuals with a dollar figure.
That doesn't mean they weren't harmed.
I don't
Just
disagree.
because it may not qualify to be paid out of the Client Protection Fund in Missouri for whatever reason, whatever parameters they have for paying claims, doesn't absolve the fact that we have a finding that they were harmed,
Well,
that they suffered harm.
I guess it's my perspective that in the disciplinary process, we are limited to, like, a lawyer that takes a retainer and doesn't do work. That is the scope. And if there's been other harms, there are other avenues that clients can pursue. As far as my perspective was, there wasn't really anything that I could specifically point to the panel and say this is the amount of restitution because of the linkage to the rule violations. I didn't bring up the restitution issue. I read to you on page 35 of the transcript the only discussion we had about any kind of restitution. And I truly did believe that if there was something that was appropriate through the disciplinary channels, that because Missouri was ahead of us, that they would have taken care of it.
I'd like to follow up with that. I understood from Mr. Odo's counsel, Mr. Hamill, that it was not so much a denial of the claim in Missouri, but also this release and settlement agreement that they produced to you and that you looked at, and that also led you to conclude there is no restitution to be made.
I'm sorry, I'm not.
We were provided a copy of the settlement agreement.
Right.
Signed by the two people who filed complaints against Mr. Odo.
Right.
And my assumption is that the Missouri Client Protection Fund Commission looked at that document and basically said, there's been a release of claims, therefore there's no claim upon which restitution would be paid to these people, therefore their claim to be paid by our commission is a non-claim. Am I reading too much into this?
Well, I don't know the reasons behind. The only thing I have from Missouri is the letter that it said it was considered and it was denied. I don't know. I'm assuming that they submitted what they submitted to this court to them. I did not ask my counterpart in Missouri exactly what was part of the consumer protection or the client protection file. But my position is the restitution issue wasn't on, it was not part of my presentation before our panel. And I truly believe that the panel picked up the fact that there was a Missouri client protection claim pending and he had not paid anything on it, to say if for some reason he doesn't follow through in Missouri and pay that before he gets back in here, we want to make sure that that is satisfied.
So your understanding of what the panel was doing was saying there are claims for restitution being made in Missouri arising out of these two people's litigation, if you will. There's some satellite litigation here.
Right.
They made claims, Missouri then denied them, and you believe the panel therefore would be satisfied that once Missouri denied those claims, there was no restitution to be made by Mr. Odo to these two individuals.
I do.
Other than the fact that we have this sentence, and this is what I've been focused on, this sentence in paragraph 39 and the hearing panel report at page 22 that talks about the Kansas Client Protection Fund and how if it gets involved, then the respondent needs to fully cooperate and repay the commission as directed. And I'm trying to figure out where that comes from and what the possible exposure is.
What paragraph are you on, sir?
39. Right above,
It's the last page
just
of the
right above the
report.
signature line of the hearing panel report. It says, in the event the Kansas Client Protection Fund also initiates an investigation and prosecution, etc., then they make recommendations. And so one of the things we have to look at are the recommendations from the panel. So what are we supposed to do with that sentence?
Well, first of all, I'm not familiar with client protection because it's outside of what I am privy to. And I don't know if there are limitations as to when one can file a claim. I know that the requirement is that you file a complaint. You have to have a complaint on file with our office in order to be able to reach the client protection. And you know, this incident happened 4 years ago, and I guess I'm just making an assumption that because they filed a complaint in Missouri, they were aware that we had a similar fund, and there wasn't a claim filed with Kansas, that is not going to happen.
And I'm not trying to argue about this, but again, from where I'm sitting, one of the first things you said was that the client restitution issue had been resolved and you weren't making any exceptions. And so I take that to be you're asking us to ignore that recommendation from the hearing panel. And so I'm asking, why would we ignore that?
Well, no, I think it would, okay, hypothetically speaking, if tomorrow they file a complaint or a claim with the Kansas Client Protection Fund, and for whatever reason he fails to cooperate, and say your order's already come out this afternoon, that could be a separate proceeding for our office to bring, and we would resolve it from that perspective. Or you could put it in your order that if they choose to file a complaint before the suspension is over, if the court chooses to suspend, that be a requirement that he cooperate. And I haven't really done a lot of reinstatement, so I did pull the rule book, which, you know, Dean Kincannon always told us, before you think great thoughts, read the rule. And 219A talks about if you suspend an attorney for a definite period of time, the attorney is not eligible to petition for reinstatement until the defined period of suspension is passed. So I'm reading that as day 366 he could come. And then B says that they need to provide an affidavit to us and to the clerk of the appellate courts that they have complied with Rule 218, that the time has lapsed, and you have to file a verified petition for reinstatement. And it sets forth facts establishing that the attorney is entitled to be reinstated to the practice of law, and they provide us a copy of that and any other evidence that the attorney has complied with the orders and conditions in the Supreme Court's order. And if the order does not specify that they have to undergo a reinstatement hearing, we then certify that based upon their affidavit that they have complied with all orders and conditions. And so I guess that's kind of the process. And then if for some reason there's a dispute as to whether or not they have complied, then we file a motion for a reinstatement hearing. And so I would just ask that the court follow Rule 219 as far as that I still ask for a definite period of time.
And I don't want to keep beating this dead horse on the issue of restitution, but in the event that these two, I guess now, or these two claimants file a claim with the Kansas Client Protection Fund Commission, saying we want some money from the fund because we've been damaged by Mr. Odo. Did I say Odo or you?
Yes.
Odo. Are you telling us that it's likely he will submit to them the settlement agreement that he submitted to Missouri, and that would then satisfy the claim or the Kansas Client Protection Fund Commission like it did Missouri's?
Well,
or am I reading way too much into this?
Again, I'm not sure if it was the settlement that created the situation in Missouri. My understanding were that some of the claims appeared to be a little tenuous, and I sure hate to speak for what Kansas would do, and I also hate to speak for the opposing counsel on what they would or would not submit.
Counsel, let me I'm sorry.
I was going to say, there's a cover letter to this agreement submitted to Mr. Christopher Yanku of the Missouri Commission. So I'm assuming it was submitted to him to send to their commission.
I think that's reasonable, yes.
And that would have been at least one basis for Missouri to deny the claim.
Correct.
So, but this is not a global settlement on all claims.
No, it isn't.
It is concerning the issues in that complaint and this complaint.
Right. I guess from my perspective, Mr. Odo would need an opportunity to determine what the amount being claimed is in Kansas and for what harm. And that has not been presented to anybody for any kind of determination. So if they would go and file the client protection, then I'm presuming that it would be investigated, that the settlement would be considered, as well as anything else that Mr. Odo might believe is relevant to either affirm or deny, that he owes the monies.
So what are we to do with this recommendation in paragraph 39 then about the Kansas Client Protection Fund Commission?
Well,
It appears to say that he has to either repay the commission or his clients as directed.
correct.
So we just wait
Well, there
to see
is,
if anything is filed.
I believe, yes.
According to our website, claims must be filed no later than 1 year after the claimant knew or should have known of the lawyer's dishonest conduct
Thank
under
you,
the Client
Justice.
Protection Fund.
And so the complaint came into our office from both of them on June 24th of 2011. So it's probably moot.
Justice Stevens?
Yeah, just was one more whack at the dead horse, I guess. My concern is back with the sentence in paragraph 39 that splits between page 21 and 22, which is the recommendation to require the respondent to establish he's made restitution to the parties. And I guess my question is just very simply, on what basis do you have any reason to believe that these two individuals have been made whole?
I honestly don't know
Okay,
that.
so how can, again, we can either, so again, I guess the question is, what do we do with that specific recommendation of the panel?
Well, because there wasn't a claim made in Kansas, I don't even know really what the Missouri claim was.
I
just knew
understand
that
we
there
have
was
an
claim.
evidentiary problem. We don't know amounts. I'm just trying to deal with the recommendation. So we either say we don't accept that recommendation, which is one thing, but all the argument I've heard today is that we don't need to worry about that recommendation because restitution's been fully made. And I just don't see any indication that restitution's been made.
Well, if I said restitution has been fully paid, that was not a correct statement. I believe that the restitution issue has been resolved through the Missouri action of finding their
i.e.
complaint
there's
was not
no
compensable.
restitution left to be paid.
Well, I don't know what damages that they were claiming.
Okay.
I mean, the harm to me was just kind of the overall reaching and the conflict of interest and that harmed their position as clients. I don't know necessarily if the panel was speaking to harm in a financial sense specifically.
Was there exorbitant interest, I thought?
There was, but I'm not sure that was actually
Paid.
right. Because one of the collateral suits was him claiming on the notes, which didn't go anywhere.
Okay.
So, and again, that was not part of what I believed I needed to prove in Kansas because it was pending in Missouri.
One more question. Doesn't your recommendation of a 1-year suspension presuppose that Missouri will resolve this and reinstate his license within the 1 year?
It does.
What if they don't? What if they? I mean, right now his application is pending. Sounds like they might, but we don't know. What if they don't reinstate? They say no, it's not sufficient, or there's something else. What?
Well,
We're in the position of possibly reinstating him prior to him being reinstated in Missouri. That could be a possibility. Is that okay with you?
Well, several things. First of all, if something occurs that they find
Not occurs.
He's
Let's
not-
say his
he's-
applicant, he's submitted an application. Let's say it's not complete. You don't know what he's done. Let's just say it's not complete or it doesn't satisfy the Missouri disciplinary administrator, and they say no, we're not going to reinstate him.
okay,
And so, but you're fine, even with that consequence, us reinstating him within
I
a
am.
year. Okay, that's what I wanted to clarify. Okay, thank you.
Any more questions? I see none. Thank you, counsel.
Thank you.
I thank all of you for your arguments.
I know it's late. I'd like to make a comment about these these issues we've been talking about?
Well, since normally it would be out of order, well, if it will help us dig through that restitution issue, I'll go ahead and allow you a minute.
I'll be brief. There are 4 conditions that are set down, starting on the last 21, page 21, paragraph 39. There are 4 conditions to be satisfied before you can be reinstated. He has to, we'll ignore the first one, that he has to make restitution. He has to cooperate with both states of Missouri and Kansas if a claim is filed against the client's security fund, and he should make whatever payments are required. That's pretty easy. And he's certainly willing to do that. We're not trying to exclude that. And he's willing to apologize. That's the other one. The one that is problematic is that he's ordered to pay restitution. But in what amount? And I know it says they've been harmed, but there's no evidence of harm of what that dollar amount is. So how can he make restitution? So if you suspend him for 1 year or 6 months or whatever on the condition that he make restitution, then in what amount? I mean, they can make a claim for anything, and is he going to have to litigate that? Is it going to be a lawsuit? How does he know? These people could just come in and say, well, you know, you harmed us for $1 million. So if you make restitution, you can, I mean, they'll just be holding his license up indefinitely. And there is due process here. And I would point to the language in this release. It's paragraph 11 in the settlement agreement. And that is about as broad a release as you can write. And it's talking about settling any and all claims between these parties. And that's the 2 claimants in this case and Mr. Odo. Any and all claims that could possibly arise out, now known or, you know.
That arise out of the Kansas case and the Missouri case. That's why
Yeah.
I said it's not a global release for all claims. But those are the reasons we're here today.
Well,
I grant you.
We didn't dig in,
I
I
understand.
didn't dig into the issues in those cases, but
If
and
they
I don't-
want, your point is if they want restitution on these issues, then it's covered by the release. But if they want restitution for some other misconduct, then they would file another complaint and go through that procedure.
well, I guess.
All right.
But I can pretty much guarantee you that those 2 lawsuits involved all of the issues, his representation of these parties over a several-year period, all giving rise to the complaints in this case. I didn't dig into it and present it that way, and it hasn't been put into evidence. So I don't know where that leaves him if he has to make restitution in some unknown amount. He could be suspended forever. And they might not even make a claim. Probably will if they read the opinion, but that'll be a new piece of litigation, I guess.
We understand your position. Thank you, counsel.
Thank you.
We thank all of you for your arguments this morning. Court will take this matter under advisement. That completes